Unitex is now in session.
Please be seated. We welcome you to our continuation of the May 8th, 2024 settings of the 7th Court of Appeals. We have one more case for this morning. We'll go on and call the docket. I know that some of you have appeared in front of us, some of you haven't, but you all should have been notified that both sides get 20 minutes per side to argue. The appellant gets an additional 5-minute rebuttal. No need to reserve rebuttal time, you get it automatically. If you were sitting here in your earlier argument, you will note that we ask questions. We appreciate succinct answers to those questions, as succinct as possible. And that helps clarify our thoughts. So with that, we will go on and call a docket. Last case we have for this morning is 07-23-00390-CV. Unitex, L.L.C, and Unitex Oil and Gas, LLC versus CT Land and Cattle Company. Okay, for the appellants. I guess we have this cross appeals appellants. We've got appellants on both sides, but let's go. You stood up first. You're the
Yes, Your Honor. I would note for the record, Rob Crumpler and Lisa Paulson, my law partner, are here for the appellants, and we're ready to proceed.
Thank you. Good afternoon.
Elizabeth Geary on behalf of CT Land and Cattle Company, the appellee and cross appellants.
Thank you.
May it please the court, counsel. This is a deed interpretation case. My clients are oil and gas operators. Their business model is to acquire mature oil and gas fields, clean them up, develop them.
Dispute. The majority of the dispute, if not all the dispute, revolve around having to bury a pipeline.
That's correct, Your Honor.
And it revolves around the provision that says something along the line of, if the lessor wants, pipeline needs to be buried.
That's correct, Your Honor. That's what the oil and gas lease provides.
And that's the oil and gas lease.
That's correct.
Who's the lessor?
The lessor under that oil and gas lease is the Fuller family. It is a long-time oil and gas family.
Who's the lessor with regard to this dispute?
The lessor with regard to this dispute is still the Fuller family.
Why?
Because they own the mineral rights, and dating back and getting into the heart of the case,
But opposing counsel argued that that lease was attached to the transfer from, and I'm gonna call it the trust, Fuller Trust, eventual trust, back in '96, whatever.
yes, Your Honor.
It was attached to that transfer to CT Land. They transfer the rights into the minerals.
No, Your Honor. Actually, so the Fuller family, in owning the 23,000 acre plus ranch for many, many years as a family, they owned a unity of ownership, both minerals and surface. And in those years of development, the minerals were leased by the Fuller family. Members of the Fuller family, eventually the trust, you're correct in the chain of title, the trust became the owner of a unity of ownership as to both minerals and surface. So we come through the chain of title, and there was always a unity of ownership right up until 1997. And in 1997, the Fuller Trust, at that time owning both minerals and surface, made a conveyance of the surface only to the Sin family and reserved all of their mineral interests at that time. They continue to this day to own those minerals out there and enjoy that production.
Did that transfer, that deed, expressly reserve the lease?
In total, I would say yes, Your Honor. But I think that what is key to this case, and for what this court is analyzing, and what we contend the trial court erred, is in her analysis of the lease, of the conveyancing and the chain of title, is what was actually reserved by the Fuller Trust when that conveyance was made. And that is the critical language that we're asking this court to consider. And let's get right into it, because my client's position,
and correct me if I'm wrong, but I didn't read in your brief any discussion with regard to CT Land has no standing to pursue their claim because they're not lessors. Is that something that was not raised at all?
we raised the issue specifically that we raised was that CT does not own the right to enforce the pipeline burial covenant, because that covenant
Was
reserved to the Fuller
because
Trust.
they got to reserve the surface.
That's correct, but they did more than that, and I think that's the distinguishing piece of it. And in the body of law,
Does it matter whether or not they reserve the surface if they're not lessors?
does it matter if they reserve the knowledge? Yes, because what you had is you had a mineral owning family across a 20,000 plus acre ranch that wanted to maintain control of the surface with respect to the mineral development. And that's what the sin deed, in the language of the sin deed, specifically reserved to the Fuller Trust. And they didn't do it in terms of, simply reserving all rights to lessor. They went a step further. They went a step further by putting in very specific language in their reservation as to the rights in the surface as it relates to the mineral development. I think in context, you had a mineral owning family that effectively was saying, we do not want you sins as new surface owners only. And the deed to the sins is very clear to say you are only getting the surface subject to the further reservations. We do not want this new surface owner to be able to control any surface activities with respect to the mineral development. And when you get into the language of itself, and breaking down that deed into the sins. Again, first and foremost, surface only. Very clear on that. Very clear on that. And they have a very broad grant of reservation of the minerals.
But in reference to surface, it says nothing about burial. And opposing counsel, the opposing party is saying, so we have a specific provision that specifically addresses burial versus this general reference to surface. And I'm assuming from that I would take the idea that specific controls over general.
Your Honor, my response is, number one, that is correct, that the reservation does not say the word burial. But I would also argue, when you get into the language of the reservation itself, it actually is very specific as to the activities that they're going to have the right in the surface to control. And as goes the pipeline burial with respect to control of the mineral development, that would impair upon the mineral owner's ability to develop. Because
But a pipeline burial runs with the land, is that right?
generally the pipeline burial under Texas case law has been recognized to run with the surface, Your Honor.
What does that mean?
My understanding from at least reading some cases and preparing for this, particularly that Fort Worth case from a couple of years ago, was it has to expressly then, if you're going to change that right, you have to expressly mention that in your subsequent leases.
And I think you're referring to the Henry, and I wanted to make sure I answered your question.
Yeah.
Okay.
Yes.
So, Your Honor, we believe that the sin deed did do that. It specifically reserved that, because when you get into that reservation, and if I could break it down for the court, because it's really two-pronged and it's really important and it goes to the heart of the case. There's really there's the paragraph that deals with control of the surface, First and foremost, what is the Fuller Trust reserving? Rights of ingress and egress at all times to the property for the purposes of mining, drilling, exploring, operating and developing for any minerals and substances described above. And rights of ingress and egress, storing, handling, and transporting and marketing of all or any of the foregoing from the property, the foregoing being the minerals. They control that. They're reserving their rights to control that ingress and egress, the methods and modes of operation and coming and going from the land. Further, it says, whether destructive of the surface of the property or any part thereof or not. It's my position and my interpretation that in and of itself is actually a specific reservation of the surface activities and actually negates the accommodation doctrine. So if they had simply reserved rights in the minerals and nothing more, you get the surface, we reserve all rights in the mineral. Common law would then apply. And what the common law says is the mineral owner, you have reasonable and necessary use of the minerals, to develop the mineral estate, subject to the accommodation doctrine. This goes further.
Burial runs with the land.
Generally
Runs with
speaking,
the land, unless
reserved or abrogated
Okay.
or abandoned.
Why not lessor burial if the lessor requests? Why isn't that a reservation? Or is it a reservation?
I think the reservation could take different forms. I think that in this particular case, they simply could have said, we reserve all rights to the lessor. But they went beyond that. If they had just simply said that, then I think that that would have been a more limited limitation than what is actually in the sin deed. Because by way of, as we continue to work through the sin deed, the first piece of it I described to you was that they reserved the surface with respect to all mineral activities, whether destructive of the surface or not, together with rights in addition to, what are those additional rights that the Fuller Trust reserved? As much of the surface of the property as may be required to permit grantor and grantor's successor in title, the Fuller Trust, to mine, develop, explore, operate, handle, transport, and market the foregoing from the property. Again, the minerals. They reserve additional rights in the surface to control the transportation of the minerals. Now, while they do not use the word pipeline burial, I don't think that's necessary. I think that this expressly, in writing by the Fuller Trust to the Sins, said to the Sin family, we are reserving these rights in the surface. It's a big property. We do not want any interference with the mineral estate. And I think the first clause abrogates the accommodation doctrine because it gives them control with respect to mineral activities as they deem as required. And it's that together with language that then, in my view, controls the surface with respect to the transportation of minerals.
With regard to the last argument you made about what is being reserved, was there any evidence that was presented to the trial court that you have to have the pipelines above ground for purposes of mining, developing, or transporting, or marketing? Because it says as required. And so it sounds like there's evidence there that you've got to show that there's something required there, right?
The evidence in the record with respect to the pipelines on the ground was substantial. And I believe the evidence in the record demonstrates that the pipelines on the ground, on the surface, was to the benefit of the mineral development, and candidly, it was also to the benefit of the surface owner. And that was uncontroverted, and that really goes to the equities in the case with respect to the specific performance and the injunctive relief. But there was uncontested, uncontroverted evidence as to why you put a pipeline on the surface. They're easier to manage, they're easier to monitor. It's better for the safety of the personnel out there. It's safer for the surface itself because you don't run over them. If there's a leak, you find it, relatively quickly as opposed to something that's buried, 10 inches
Are
underground.
there any fullers alive?
Yes, Your Honor, there are.
Were any of them the one that executed or created the trust and executed the transfer back in '97? Was he called to testify and explain what was intended?
None of the Fullers testified in the trial court. With respect to the court's specific question as to who's living,
I'm just wondering if
I
there's
know
any
that members of
testimony.
the Fuller family are alive and well in Midland. Yes, Your Honor. But that goes back to Justice Austin, this concept of it being on the surface. That enhances the mineral development. I mean, think to yourself a field. In this particular instance, the portion of the Fuller lease that Unitex operated is roughly 2,000 to 3,000 acres. Call it 2,500 acres. There's literally hundreds of miles of pipelines on the surface, and they've been there, uncontroverted in the record. They've developed over time. Charlie Wilson, who was one of the more unique witnesses, I thought, he had the history on this lease going back to the 1990s. And he testified that there's literally hundreds, if not thousands of miles of pipeline on the surface, and that's been the case since the mid-1990s. So, they've been there forever without anybody contesting it, without anybody raising any issue to it, at all. And Mr. Wilson testified uncontroverted, that was done first working with the Fuller family when they had unity of ownership between surface and minerals. Then he worked with the ranch foreman for the Sin family. And then when CT bought the ranch, he worked with the foreman at CT. And CT sat by for 7 years while they owned the ranch and never did anything, never contested laying lines on the surface. Not one time. It was really only in the context of an access dispute between the parties that the pipeline burial covenant was even raised for the first time. Literally in the course of a lifetime of an oil and gas lease that dates back to the late 1940s. So you can just imagine the inequities of an operator going out now in 2024 and burying literally hundreds and hundreds of miles of pipeline.
Well, I agree with you that there are policy concerns with enforcing something like this, but nevertheless, you do have paragraph 6 that begins with the word when required. It doesn't have a limitation on when that date goes away. Given that and the fact that it runs with the land, unless we've got this modification out from these reservations, that seems to work against your position. I understand what you're arguing is on the reservation, so.
My position on the when, and that's a really good point, and I think that the case that was cited for the court, it's a federal case out of Louisiana, it discusses the temporal aspect of the reservation itself, or the pipeline burial covenant, and that covenant is, I believe, if it's not word for word identical, it's almost identical to what we have. It puts the pipeline burial covenant in context of you can't basically drill a well within 200 feet of a residence or a structure on the property. The utilitarian, viewpoint of the construction of a contract.
Why doesn't the law imply, since it says when, but there's no time limit in relation to when, why does not the law just imply a reasonable time like it does in option contracts? You have the right to buy this, so it doesn't say exactly when the life of that is, so we're gonna apply a reasonable time. Did you argue that?
We did not, no, Your Honor, we did not argue that. That was not, in certainly being familiar
Is that
with,
part of latches?
I do believe it would be part of latches, because as, I think as that Louisiana federal court recognized, it would be unreasonable And the when, you would contemplate that you would make those elections when construction was being done on the particular aspect. And that, and to raise, and with just a couple of minutes left, a couple of final points. I think that my point is further evidenced by what the court actually did, both in terms of award of specific performance and the mandatory injunction. The trial court, in making those orders, literally borrowed the language out of our reservation. The court literally tracked the language to say, Unitex, you are ordered to remove the pipelines on the surface that are used to transport the minerals. I mean, the language comes out of the reservation. The order of the court literally contradicts the reservation that the Fuller Trust made way back when it went to the Sins. On the latches piece of it, Your Honor, we obviously believe that we're correct on the contract interpretation piece of it. A final point on the reasonableness, to further answer the court's question. It goes to the utilitarian interpretation of a contract and not lead to absurd results of the fact that a surface owner, again, we contend that CT doesn't own the right, but they can come in after the fact and use this as a hammer, which I believe the evidence in the court, undisputed evidences, was its intent to try to, frankly, get more surface damage.
Even do the same if there was not a transfer of the surface back in '97, and the Fullers still owned it, and they came in and said, I want you to go back and bury yours.
If the Fuller said that, I think.
The lessors said that.
If the lessor said that, then obviously we're not arguing about who owns the right.
I understand.
But I think that our affirmative defenses, which were all uncontroverted and I believe conclusively established in the trial court, would be an issue to be tried with the Fullers. But, I mean, again, none of the latches, the limitations piece of it, the abandonment piece of it, the abrogation piece of it, the waiver piece of it, all of the evidence that we put in the record with respect to the timing, and I'll finish.
Go on and finish your thought.
All of the evidence that we put in the record conclusively established all of our affirmative defenses in the case. So even if this court would rule as a matter of law that CT actually owned the right, I also believe that the evidence went uncontroverted and legally established as a matter of law affirmative defenses.
I've obviously seen cases where the finder of fact finds latches and then the case is appealed to the Court of Appeals to assess the evidence. Have you cited evidence or have you cited authority for an appellate court finding latches as a matter of law?
I rely upon the factual record whereby the passage of time, Mr. Wilson's dealings with all of the surface owners through time, the significance of the 100 miles of the pipeline, the preservation of the surface, the help in the development of the mineral estate, none of that was controverted. So what I rely upon is the conclusive evidence in the trial court to ask that this court can rule as, find that.
You're saying that you proved as a matter of law latches, as a matter of law waiver, as a matter of law. So we're not having to find anything, it's just a legal conclusion.
That's correct, Your Honor. Thank you, counsel.
May it please the court. Your Honors, this is a case where the grantor transferred the surface rights and without limitation, the lease for all purposes. Your Honor.
You said they transferred the lease, the mineral lease?
The surface rights to the lease for all purposes, and we have specific language in the deed that provides that.
What specifically says in the deed they are transferring all the surface rights as contemplated under the lease?
On page 2 of the deed, Your Honor, which is the 5th record volume, it's Exhibit 2. On page 2, the conveyance of the property to grantee, their heirs, successors, and assigns is made subject to all valid leases. It goes on to say, without limitation, those described in Exhibit B, which was the lease, attached hereto and made a part of for all purposes.
Doesn't that mean to not transfer the lease?
The surface rights to the lease. And that's exactly, Your Honor, what the Fifth Circuit said in Magus. In that case, the difference is they had already transferred the lessor's rights in the lease. Here, this specifically states that in every way that the lease touches this property and affects this property, this deed is made subject to that lease. That on page 2.
Okay. And you called yourself, if I remember right, reading your brief, you called CT Land the lessors.
CT Land is the successor in interest to the
No,
lessor.
you call them the lessors. So you're invoking the provision that says, when required by the lessor, these pipes can be buried, will be buried.
Correct,
So you're saying you stepped into the position of the lessor.
correct, Your Honor.
Who's the lessors under that deed, under the mineral?
Originally-
The lease, excuse me.
Originally, the Fullers were the lessors. In the 1997 deed, the Sin conveyance, the Fullers transferred the surface rights to the lease to the Sins. The Sins.
You're reading that as saying that save and accept or whatever, accept the lease, you're reading that as saying that actually does convey rights under the lease.
Well, for 2 reasons, Your Honor. First,
Is that what you're arguing?
yes, but also, Your Honor, and just to be sure, it says subject to. Earlier on, it says save and accept.
I am
all-
conveying subject to the lease.
Correct.
Doesn't subject to mean we're not conveying the lease?
No, actually, it says, as the lease affects the property. The property on page 1 is identified as the surface. And so by identifying, attaching the lease and saying this surface property is being conveyed subject to the lease, and I'm quoting, without limitation, for all purposes, as it affects this property. The property is identified as the surface. That's the first reason. The second reason is that Texas courts, such as the Texas Supreme Court and Chronic Partners, and this court has very clearly made known that unless a right or a part of the property is reserved, it is conveyed. The greatest estate is conveyed. We know here that the language that opposing counsel is referring to about reservations, that tracks specific language that every single mineral owner in Texas has a right to. For example, use of the surface. This court knows from Coyote Lake, the Coyote Lake case, that a mineral owner always has rights to use the surface. That is part of long-standing Texas law. As the Texas Supreme Court has noted, the mineral owner is known as the dominant estate, not because it is somehow superior, but because it has access to use the surface as is reasonably necessary. Second, opposing counsel relies on the reference to destruction of the surface. Now, we have an extensive discussion of the prior references to surface destruction in Texas case law in our brief, in our second brief, the Applebee's brief. Previously, there
Does it
were.
matter, surface destruction, if the document is reserving ingress and egress, development, and transportation, etc., in relation to the surface?
Those are all rights that every mineral owner in Texas already has, Your Honor. That's
So they're redundant.
correct. And that's exactly what the Fort Worth court said in Henry versus Smith just a couple of years ago when it considered this exact issue
So
on.
why put them in the lease if they already have them?
It's been a practice of long-standing.
Can you use a lease to change the rights that the law says the surface owner or the mineral owner has?
Now, are you referring to the lease or the deed, Your Honor, as far as the lease changing or the deed?
Either.
Well, the lease certainly can define what the rights are between the mineral owner and the lessor. A deed cannot affect those rights that had been previously conveyed in the lease, but it can certainly divide those rights when the surface and the mineral is severed, as it was in the 1997 deed. And that's what the Henry Court stated, is that this particular deed just reiterates the rights that a mineral owner already has in Texas. It has the right to use the surface. It has the right to destroy the surface. And in fact, the Texas Supreme Court said that in the Moser case in 1984, when it said that, yes, the mineral owner can destroy the surface. This does not mean that the surface owner does not have a right to compensation.
The mineral owner can put pipes on top of the land.
Normally, yes, Your Honor, except whenever there is a provision such as this, that when required by lessor, the lessee will bury the
Goes back to my
pipelines.
question, you're the lessor.
And here,
Is CT named in the mineral lease?
no, absolutely not. CT Land is a successor in interest by title.
Is CT land a assigned successor in interest under the mineral lease?
Correct. That is our contention, Your Honor, that the 1997
So
deed,
they have some rights in the lease.
correct, Your Honor. And that's
Where are
exactly,
those rights limited?
well, what the lower court decided, and this is.
No, I want, you tell me, where are those rights limited?
As far as those rights, only the rights that pertain to the surface owner's rights under the lease that had been conveyed in 1948, such
And
as,
the deed specifies just the surface rights under the lease.
the deed identifies the surface as the property. It then states that this is being transferred subject to all of the lease's rights and responsibilities without limitation for all purposes, and I'm quoting, that affect the property, and the property is defined as the surface. And this is what the Fifth Circuit also decided in Mangus,
What's subject to me? I guess that's what I'm having problems with.
meaning that when a property is conveyed, it has an appurtenance. It has a covenant that runs with the land, which is the lease. Therefore, it is transferred with the lease. The land comes with the lease attached, and therefore, both the rights and responsibilities are transferred. And here, the grantor specifically said they are transferred as they affect this property. The property is defined as the surface. Opposing counsel admitted that there is no argument that a pipeline burial provision is typically owned by the surface. And that's what.
Well, that's reserved.
Unless it's reserved, absolutely, Your Honor. But this language
Why wasn't this reserved to the lessor that's named in the lease?
because the lessor did not specifically reserve these rights as the lessor did in Mangus. That's the
Only the
difference.
lessor had the right to do this, though.
Correct, but the lessor did not. And if this court will,
Exactly, the lessor did not, and only under the lease, the lessor was the only one that could do it. Yes, and CT is not the name lessor.
the lessor is the one that could reserve it. If the lessor, under longstanding Texas law, if the lessor did not reserve those rights under the lease, it transferred as the greatest estate should transfer under a deed. And we know here that the language of the reservation that opposing counsel is referencing, those are already rights that every mineral owner holds.
Let's say that you're right. Let's say that you're right, that you've got a contractual right that you've held since 1948. One of the things we look at when we're looking at breach of contract issues is whether or not the remedy would result in waste. This sure seems to be a wasteful act to require these pipelines to be buried merely because your clients decided to have the pipelines buried. Can we take that into account in the course of drawing an opinion?
Only to this extent that, in our contention, only to the extent that it's a factual sufficiency argument, because those are factual questions that are presented to the court. Now, I don't believe waste was argued at the lower court. Latches.
Latches is a similar argument, it's saying there was a passage of time that you or, not you, your client or previous lessors, if that's the term we're going to use, stood by and watched all of this occur. But I think the remedy that we're talking about is still a similar remedy, which is, we understand that this may be a right that you've got, but this is contrary to the economic interests involved for the benefit that your client's going to be receiving.
Well, here's the problem. Unitex failed to prove that at the trial court. Now, opposing counsel said there was substantial and uncontroverted evidence. That is absolutely not true, and we provide that in our brief in multiple places. The only question that now Unitex points to, because it first cited stricken testimony to this court, because Unitex did not qualify an expert to testify on these issues, that it would be impossible or that it would be extremely expensive. And the district court found that expert testimony was required to testify on this issue. That wasn't appealed to this court. That stands.
Was it contested that there are hundreds of miles or 100 miles worth of pipe out there?
I don't believe the actual mileage is contested, but in order to reach the conclusion that that means that it is wasteful or that means it is impossible, Unitex had a burden to
Was there a
prove that.
discussion, the evidence of how much miles of pipe were out there, the quantum of pipes out there?
I believe there is some testimony in the record, Your Honor. However, there is no testimony that provides to the court the opinion that because there are that many miles, because there's that many pipelines, that it is either impossible or that it is wasteful or that they are unable to do it.
Your client is engaged in farming operations, is that correct?
Ranching primarily, Your Honor.
Ranching, okay. All right. The predecessors and of owners of the surface, what were they involved in, if the record reflects?
My understanding is that this property has been used for ranching for decades, and that's what the testimony reflects, is that it's primarily a ranching operation. And
This
so,
is the property that abuts the Snyder Highway, going down from Post to Snyder?
yes, Your Honor.
And you can see it from the road.
Yes, that's correct, Your Honor. It's 4,000 acres, and that's why expert testimony was required here, and why Unitex.
Question, with regard to specific performance, is that equitable?
Because of the language that the
Well,
parties.
no, it's the remedy of specific performance, is that an equitable remedy?
Yes, Your Honor.
Like injunctions an equitable remedy, you look at the hardships involved. Is that true with regard to specific performance? You look at the hardships involved in ordering specific performance to them?
In the way that it would be tied to a permanent injunction, yes, Your Honor. And that is what we contend Unitex just wholly failed to prove at the trial court. Did not certify an expert, did not get evidence in
Who's
on
the
the
plaintiff
cost.
in the trial court?
The plaintiff originally was Unitex, but both parties had claims. And so, and
If
Unitex,
you're asking for specific performance to require a change to be made, did that not put a burden on you to present the evidence that this is equitable under the circumstances?
to the extent that we can show that we are entitled to it, but we don't have any burden to disprove their affirmative defenses in order to get
That's
to.
what Justice Dawes' question is, since there is not a prohibition initially from putting pipes on the ground, you're invoking the purported right to bury them, and you're demanding specific performance. Wouldn't the burden be yours to gain specific performance, that it would not be harsh, if not, I use harsh, burdensome, unduly burdensome on the opposing party to get specific performance?
No, Your Honor, and the reason is that we should not have to disprove that it can be done. If that is an affirmative defense, if it's an affirmative defense that this is wasteful or that this is impossible.
Wouldn't you have to prove that it can be done?
Yes, Your Honor, I believe the testimony shows that it can.
And
The
you have
only-
evidence of record to indicate that it can be done?
To the extent that Unitex argued that it cannot be done, Your Honor, that is one question in the record. There is no follow-up, that it's on its third record, and it is page 245, and it
Just
asks.
follow up on Justice Dawes' question, did your client present evidence that it can be done?
I don't believe that my client certified an expert to show that it can be done. It was not my client's burden in our contention to disprove their affirmative defense. They had to prove their affirmative defense that this was impossible. That's what they argued at the trial court. They did not certify an expert. The only question that they now point to in the reply brief after conceding that they had cited stricken testimony to this court is in the third record, page 245, where a Unitex employee was asked, why don't you bury the pipelines? And the Unitex employee responded that, well, in rocky areas, it's too hard. There was no evidence on why it's too hard, and no evidence on where in this 4,000 acre property could it not be done. There was no evidence from an expert to show why the ground in those particular areas is impossible to bury the pipelines.
Curiously, is Unitex the only lessee, mineral lessee out there?
As far as CT Land's property interest, I'm not sure, Your Honor, but as far as this particular case, this is the only one in
CT
dispute.
Land was conveyed 23,000 surface acres.
Yes, in this
This is
particular,
only 2,000 or 3,000 acres.
this is 4,000, is my understanding.
4,000. Are there any other pipes out there? Any other lessees out there? Does the record show that?
I'm not sure if the record shows that, Your Honor. I will have to follow
Opposing
up.
counsels admitted that, at least in a footnote, that there are others out there that your client's not requiring that they bury. Why is that?
Your Honor, it's irrelevant to this case. My client has a
Well-
right under the lease.
I'm asking. To me, it's relevant, so answer a question I think is relevant. Why does the record show that?
Your Honor, the record may show that. I don't think there's evidence in the record that explains the why to why there might be another lessee out there.
But there's
that has-
evidence in the record that not all lessees are being required.
And
Is that right or wrong?
I believe that's correct, Your Honor, but here's the thing. Those leases, and we don't know because this is not before the lower court or this court, may have not had a pipeline burial provision. To the extent that someone has a pipeline burial provision, they should not be precluded from exercising it simply because they aren't able to exercise it with all pipelines. Any pipelines would be better buried for the surface owner. And Your Honors, I do want to get to the fees issue because I believe that this court can interpret a deed on its surface and that the fees issues is important because this is a case where a party should not lose entitlement to a right to relief simply because a judge leaves office.
Let me ask a question along those lines. Suppose at the end of the case, after Judge Caruth had heard the evidence in the case, said, here's what I'm going to do. New judge takes office and says, I've looked at the motion for new trial, I'm going to grant a new trial. Could the court do that?
Yes,
Judge Grace could grant a new trial.
yes, Your Honor.
If Judge Grace could grant a new trial in its entirety, why is your argument that Judge Grace is in error only as regarding the attorney fee question?
Because the determination of attorney's fees on Chapter 37 is whether it is equitable and just, and that is a discretionary determination. And
That's a
so,
question of law.
yes, but
The authorities you cited say a succeeding judge can't adjudicate questions of fact without looking at being the one who heard the evidence in the first time.
well, the Texas.
They can do questions of law.
So the first facet of the multifaceted approach of the Chapter 37 determination of fees is unique. It is a matter of law, but it's discretionary. The Texas Supreme Court says this.
So applying the law is discretionary?
Determining whether it is equitable and just is
Isn't the whole thing
discretionary.
discretionary?
Just the first facet of the two-faceted approach under Chapter 37 is discretionary. The second facet is like every other determination of attorney's fees, of whether they are reasonable and necessary. And so Judge Grace had the authority to determine the amount of reasonable and necessary fees. And therefore, this court should affirm the partial judgment and remand.
Back to my question to you from a moment ago. If the court has the ability to grant a new trial and say, all right, I've now considered the evidence, I'm going to deny your fees, that basically would supplant Judge Caruth's position on attorney's fees, but he seems to have jurisdiction and authority to do so. And so that's why I'm curious about why the outcome would be different under these circumstances when we don't have a new trial grant.
The only way that Judge Grace could set it aside under what Unitex has argued is if it is duplicative, if it is part and parcel. That is a question that the court could make as a matter of law in interpreting the two claims, the declaratory judgment claim and the breach of contract claim. That is the only way that Unitex has argued that Judge Grace could set it aside. And I wish I'd had time to argue about duplicative.
Well, would you, I'd like to ask a little bit about that. The relief seems to be very, very similar in what was ordered. Why isn't it duplicative?
It goes above and beyond. So the difference here in MBM Financial, which the Unitex relies on, Texas Supreme Court case that says here the declaratory judgment claim was duplicative, it was part and parcel breach of contract because the declarations literally just recite the elements of breach of contract. Here it's different because this is a declaration that declares rights under a deed that occurred 50 years after this lease. Your Honor's brought up standing. Essentially, CT Land had to prove that it had standing before it could even get to the very first element of breach of contract. Now, if Judge Cruz's judgment stands, CT Land
What is the
has
first element of breach of contract that you're alluding to?
that the parties had a contract. And Your Honor,
So you have to show the parties had a contract. Isn't that what you were doing in the declaratory, showing the parties had a contract?
not entirely, just because it may touch on and be related to one of the elements does not mean that it is part and parcel. Here we get relief that is above and beyond a breach of contract relief because we have a declaration now that shows that CT Land acquired the right to enforce this right. There's a right in the same provision that states that the lessor may refuse to require any wells around buildings that were in existence at that time. So for example, years down the road, a successor to CT Land could take this declaratory judgment and say, this matter has been adjudicated. That is above and beyond a breach of contract adjudication.
I just had one more, I'm sorry. It's your position that the attorney's fees were segregated then purely for the declaratory portion, not for the portion that involves the interpretation of the contract or anything else that would have already been addressed?
No, Your Honor, I don't believe that fees were segregated at that point because of the discretionary determination of a declaratory judgment claim. All fees can be awarded, which we interpret Judge Caruth to have done in this case.
Thank you, Counsel. Kubota?
This court. On rebuttal, let me address some of the issues you raised.
The 1997 deed transfer interest in the lease,
Transfer interest in the lease.
at least with regard to the service.
No, Your Honor. Our position is it did not because of the specific reservations made by the Fuller
I
Trust.
understand when you're referring to the reservation regarding transportation, surface, etc. But reference to when the deed refers to the lease itself, I wish I could remember the express language,
It's subject to.
subject to, does that mean you get rights under the lease, subject to, or does it mean you're not getting rights under the lease?
It means when you take the surface, you are subject to those oil and gas leases, in addition to all of the other terms and conditions of that deed. So,
Okay, if one of those lease terms says the lessor gets to choose whether to bury, was that transferred?
no, under this particular deed. Historically in Texas courts have recognized that a pipeline burial covenant is a covenant that typically runs with the surface, save and except some other term of the conveyance. So, let's just for sake of argument, if the Fullers had just simply said to the sentence, you get the entirety of the surface subject to our oil and gas leases, and they said it in those terms, subject to, and they did not reserve out any of the further rights in those oil and gas leases because there was a unity of ownership between mineral and surface. That's the Manges case. In Manges, when the conveyance was made, they reserved out all rights of lessor because of the unity of ownership between mineral and surface. At that time, when they reserved all rights of lessor, they reserved the pipeline burial covenant, in that particular language. So, with the sin deed, had the sin deed from Fuller Trust to Sin, had it simply said, you get all of the surface subject to our oil and gas leases, that's Henry. That's saying, you as lessors, you did not reserve out that surface, that element of the piece of the surface, which was the pipeline burial covenant. It would have run with the surface. And in this case, it would have run to CT. But that's the hypothetical that is not this case. This case is a deed with very specific reservations to the mineral estate, the Fuller Trust, with respect to the surface and the control of the surface. And that's the distinguishing piece. And that's a rebuttal to a comment by Appellee's counsel that was redundant. I think the word redundant was used. What the word I would use is surplusage. Are you saying that those reservations and specifically the reservation of the activities as it relates to the surface, that's just surplus? Absolutely not. Absolutely not. Because of the detail and the specific reference to the surface and the activities that the Fullers were reserving the rights in the surface. Most notably, because we're talking about pipelines.
Which parts are different from with the common law right that the mineral interest owners would have?
It's broader, because the accommodation doctrine says, mineral owner, you get reasonable and necessary use of the surface, and you have to accommodate an existing surface use. That's straight Texas common law. I believe these provisions go further than that, because it doesn't, first of all, it doesn't say we get as much of the surface as is reasonably necessary. It says we get what's required, and we can destroy the surface, no matter what that may mean in connection with all of these various activities. So I think that it negated the accommodation doctrine, and it negated or abrogated the common law with respect to those activities. There's other evidence of that, Your Honor, and there's really two more provisions of the deed that I think are important. Number one, the as-is provision. It put the grantee on notice. You're taking the surface subject to effectively everything that is filed of record and everything that's visible on the lands, hundreds of miles of pipeline, wells, a very mature oil field.
The record literally doesn't have evidence of hundreds of miles of pipelines.
No, it does, Your Honor. Charlie Wilson testified to that, and Jonathan Wells also testified to that, undisputed. And I would also, I see I'm out of time, Your
I
Honor.
want to finish up your idea, which you're commenting.
Yeah, so the comment just goes to, really the importance and the crux of this case goes to the language of the underlying deed. And we would simply ask the court to construe those deeds as a matter of law and rule as a matter of law that CT never owned this pipeline burial covenant because of the reservations that the Fuller's Trust made. I believe this court can reverse and render the entirety of the case in favor of my client, Unitex.
And what do we do with the attorney's fees issue?
Deny it, Your Honor. I think that for the reasons stated in our brief, I think Judge Grace was correct in making rulings as a matter of law that CT was not entitled to any attorney's fees. And if the court reverses on the deed interpretation issue, or alternatively finds that we establish all of our affirmative defenses as a matter of law, they wouldn't be entitled to any attorney's fees.
Did Judge Grace specify the reason why he's denying?
No, Your Honor, other than all we have from Judge Grace is what is stated in his final order that disposed of all remaining claims in the case, which made the partial prior judgment become final, because at that stage in proceedings, the only thing left before the court was the attorney fee claim.
Questions?
I was gonna read your conclusion and prayer in your brief asks for reversal and rendition, or on the alternative, reverse the judgment and remand for a new trial. Any other reason why you're asking for a new trial?
Only if this court would find that there were errors committed, that it needed to be tried in a different way, candidly, Your Honor. I think rendering is what we would have the court do. And as a further alternative, and I'm sorry, Your Honor, look like you're asking a question.
No, just thinking.
She's not a poker face. Any, does that cover what you're saying? Thank you,
Thank you for your time.
Case is submitted and you are excused to go, and appreciate arguments presented by both sides. Helpful, and that sounds like you guys know your positions. It's just up to us to try to figure out with these